Mr. Speaker, I will be sharing my time with the member of Woodridge. I rise today not to debate ideology, but to defend a principle that every Canadian holds dear, the right to feel safe in their own community. From Richmond to Vancouver, from Kelowna to Surrey, Canadians are witnessing a justice system that no longer protects them. Violent offenders are arrested, brought before a judge, and then, despite long criminal histories and active bail conditions, they are released again, sometimes within hours, sometimes with fatal consequences. Let me tell you about Dory Dunn, a 30-year-old woman from Surrey. She was murdered in her own home by a man who had been released on bail, despite facing robbery charges and having a long history of violence. Her death is not inevitable, it is preventable. Or Jordan Paul Campbell Mitchell, who had 10 outstanding warrants. While out on bail, he set 2 police officers on fire during an arrest attempt. And Mohammed Majidpur, with over 24 prior convictions, who assaulted a woman with a metal pole and committed arson on the same day. He had been released on bail multiple times. These are not isolated incidents. They are the result of a justice system that prioritizes procedure over protection and leaves communities to bear the consequences. And the numbers don't lie. Between November 2022 and December 2023, British Columbia held nearly 4,800 bail hearings. In those, crime prosecutors sought detention in only 23% of cases. Judges granted detention just 41% of the time. In violent crime cases, judges ordered detention in only 43%, even when the accused was already out on bail for yet another violence offense. In Kelowna, 15 repeat offenders were responsible for over 1,300 police files in one single year. That's one police interaction every 4 days per person. This is not a justice system that protects the public. It's one that enables repeat offenders. At the heart of this crisis is Bill C-75. Passed in 2019, it introduced the principle of restraint, requiring judges to release accused offenders at the earliest opportunity under the least restrictive conditions. While intended to ensure fairness, it has had the opposite effect on public safety. Judges now feel bound to release individuals who pose a clear risk. Repeat violent offenders exploit the system. Crown prosecutors, constrained by federal policy, seek detention in fewer than 1 in 4 cases. Even when they do, judges often decline. This disconnect between the Crown and the judiciary is not just procedural, it's dangerous. It creates a system where public safety is treated as secondary and where legal technicalities override lived realities. Meanwhile, our peace officers are sounding the alarms, and it's time to listen. Police officers are arresting the same individuals repeatedly, only to see them walk free. They face burnout, frustration, and rising violence. In Vancouver alone, last year saw 6,200 violent crimes, including nearly 5,000 assaults. Assaults on public officers rose by 28% in a single year. Vancouver Police Chief Adam Playmer has called for urgent bail reform. Deputy Chief Howard Chow said, reverse onerous bail provisions would, in his words, dramatically improve public safety. Even Vancouver Mayor Ken Sim, speaking bluntly, said, excuse my language, but that is BS, when he was talking about a man with 60 police interactions who was released yet again only to commit another violent attack. This is not just a policing issue, it's a public safety crisis. And while the system fails to contain repeat offenders, victims are being re-traumatized. Imagine surviving a violent crime, reporting it, and seeing your attacker walking free days after, back into your neighborhood, back in your life. There's no justice in re-traumatization. Victims often face sleepless nights, anxiety, and fear, not just from the crime itself, but from the knowledge that the system may not protect them. Families like that of Tory Dunn feel betrayed. Survivors of assault and harassment are forced to relive their traumas every time they see their attacker walk free. There isn't just emotional, it's systematic. When victims see attackers released without consequence, it sends a dangerous message that their pain is secondary, that their safety is negotiable, and that justice for them optional. Across Canada, people are asking, why are violent offenders walking free? Why are police arresting the same person over and over again? Why does the system seem more concerned with the rights of repeated offenders than the safety of law-abiding citizens? The answers are buried in legislation that prioritize lenience over logic, and in judicial culture that has lost sight of its duty to protect. A recent survey shows that 68% of Canadians now believe the bail system is too lenient, a drastic increase from just 41% 3 years ago. That isn't a perception problem. It's a reflection of lived experience. Now, Mr. Speaker, I know what the Liberals and their NDP allies will say. They will argue that tougher bail is too harsh. They will say criminals deserve a second chance. But how many second chances should a repeat violent offender get before an innocent person loses their life? How many times should a small business owner be robbed before we admit the system is failing? The truth is, our opponents are more concerned with ideology than with safety. They lecture Canadians about root causes while ignoring the root fact. That is, when a violent offender is behind bars, they cannot harm innocent person. That's why we are supporting the jail not bail motion. This is not radical, it's reasonable. It does not target first-time offenders. It does not strip anyone of their rights, but it does say if you have been convicted of 3 or more serious offenses, you should not be eligible for bail, probation, or parole. If you charge with a major offense like sexual assault, home invasion, or firearms offense, you should face reverse onus bail. Judges must consider your full criminal history, not just the current charge. And if you have recently been convicted of a major offense, you should not be released again while facing new charges. This is not about punishment. It's about prevention. It's about protection. It's about restoring trust. Let's stand with victims, restore safe streets, and act now. Because justice delayed is danger delivered, and Canadians cannot wait for more.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. When you think of Bill C-75, something the Conservatives have brought up a lot today, think in terms of what it actually does, or did. It abolished parliamentary challenges to jurors and modifies the process of challenging a juror for the cause and judicial standby. Enhanced measures to better respond to intimate partner violence, provided additional measures to reduce criminal justice system delays and to make the criminal law and the criminal justice system clearer and more efficient, facilitated human trafficking prosecutions, and allowed for the possibility of property forfeiture. I'm wondering if the member could indicate whether or not the Conservative Party would actually repeal Bill C-75.
The Honourable Member for Richmond Centre.
Mr. Speaker, I'm new to this House, but I have one observation so far. When the my learned colleagues on the other side of the chamber make a statement of their achievement, it could mean a very small step, but they left out 99 steps that they have not addressed. So by saying that the Bill 75 have made some progress, it's left out many of the loopholes, or many of the gaps, and many of the challenges that our ordinary citizens are facing and suffering from.
Hear, hear.
Questions and comments? Questions et commentaires. Le député de Gaspésie, les
The honourable member for Gaspésie, les Îles de la Madeleine. Thank you, Mr. Speaker. I'd like to thank my colleague for his speech. He related some events that passed in his part of Canada. I'd like to talk about a decision that came out yesterday in my part of the country. There was a man with no criminal record who was accused of armed sexual assault against 3 victims over a relatively short period of time. So he was detained once the charges were laid. He's been in detention since April. And yesterday he tried to get bail. And you know what happened? It was rejected, Mr. Speaker. And this gentleman is still behind bars. And why? Because in the criminal code, there are already a number of tools that allow the courts to keep a person in jail, even though they still haven't been convicted, but if they might be a danger to the public. So my question is for my colleague, what is lacking from the criminal code to make sure that dangerous people are not kept behind bars? The honourable member for Richmond Centre.
Speaker, I find that information very inspiring and interesting, in the sense that because we are talking about repeated offenders, violent offenders who have committed crimes on many occasions, and they're being allowed to be walking free on the streets. And as I mentioned in my speech, only about 1/4 of those people would be given a detention. So these people are walking on our streets, threatening the safety of the general public. So we are not talking about one individual case, but we're talking about a phenomena which has been going on time and again in our community.
Questions and comments? Questions et commentaires. The member for Yorkton Melville.
Thank you, Mr. Speaker. What the member observed on the other side of the floor was very astute, that they do come up with bills that always have something of value in there, but there are always poison pills that make it impossible to support, and that was the case for us with C-75. The Liberals always say that over and over today in the House, they said, we are committed to strict measures against violent offenders. So that means that every example that was given on this side of the floor of the horrific things that have been done by individuals who've been in and out of bail are not violent offenses to them, and that is very disturbing. So what I would like to know from him is, if the Liberal government supported our motion, jail not bail, would your communities once again be a far safer place to live and raise a family?
The honourable member for Richmond
Mr.
Centre,
Speaker,
Markle.
these Canadians have spoken. 68% of Canadians said that our current bail system is too lenient. We can talk to the law enforcement officers. We can talk to mayors and councillors all over the country, and they are going to tell you the same thing. There's a crisis in their communities, and they need a reform in the bail system.
Hear, hear. Hear, hear.